here this afternoon in relation to a post-conviction petition that had been filed originally by Mr. Schick. Mr. Nieman also obviously represents Mr. VanHoutte. The original motion set out things that occurred subsequent to Mr. VanHoutte's plea. Short version is that in reviewing the file, I recognize that there was an error in your plea at the time, Mr. VanHoutte, in relation to the MSR term. While that was pending, the 3rd District, which is the district that we report to from Rock Island County, decided in an unrelated case out of Henry County in an almost exact similar situation that your plea was void. And we were back to court this afternoon in relation to either setting trial dates or having you re-enter a new plea based upon negotiations with the state. Do you understand that, sir? Mr. VanHoutte, like I said, because the original plea was void, we are right back at square one, so I'm going to have to admonish you just as we did back in May of 2010. So, the allegation says, Mr. VanHoutte, that between the months of June and July of the year 2009, at and within the county of Rock Island, the state of Illinois, you committed the offense of criminal sexual assault in count 1. And obviously, you now admonish as to the new term of the mandatory supervised release, which is 3 years to life. And obviously, on top of that, as I explained to you before, is that you will be registering as a sex offender also for the rest of your life. Do you understand that? Yes, sir. The mandatory supervised release term of 3 years to life takes precedent over the 2-year term, so the 2-year term will actually merge into the 3-year to life term. Do you understand that? Yes. Now, you understand again, Mr. VanHoutte, in relation to all of these charges, you still have the absolute right to have a trial in that. You do not have to plead guilty. You are presumed innocent as you stand there again today. That presumption of innocence remains with you throughout the entirety of the proceedings, is not overcome unless and until the state can prove your guilt beyond a reasonable doubt to any of the charges that have been filed or amended. Do you understand that? That you still have the right to remain silent, not say or do anything at trial, and the state cannot use that silence against you, but you do have the right to cross-examine and confront all the state's witnesses. You have the right to present any evidence or witnesses you feel are necessary for the presentation of your defense, and you alone determine whether you will testify or not at trial. Do you understand that? Yes. You understand that when you plead guilty, you waive your right to having a trial and those rights within a trial, and you ask me to accept your plea pursuant to the new negotiations you've entered into between yourself and the state. Yes. This plea of guilty and waiver trial by judge and jury, does that bear your signature, sir? Yes, sir. Did anybody promise, threaten, or force you to sign that document? Factual basis, Ms. Kosovich. Mr. VanHoutte, knowing the factual basis and knowing the penalties to be imposed in this case, is it still your desire to enter the plea of guilty? Next, Mr. VanHoutte, you have the right to have me determine your sentence after a background investigation done by the probation office. Everything good and bad about your work, school, family history, and prior record be put into a written report. And then we'd have a hearing. The state could introduce evidence in aggravation to get you a greater sentence within those range of penalties that I indicated. You have the opportunity to introduce evidence in mitigation to minimize any sentence that you could get. But you have signed this waiver of pre-sentence report and hearing mitigation. Is that your signature, sir? Understand by signing that, you're waiving your right to having the hearing and asking me to sentence you only to what you agree to and nothing else. Is that correct? And I would note that waiver is knowingly and voluntarily made as accepted pursuant to the agreement as to count 1. You were sentenced to 4 years in the Illinois Department of Corrections, followed by a mandatory supervised release term of 3 years to life. That is an 85% sentence, so you will serve 40.8 months according to my calculations. In relation to count 2, following your sentence on that, you will serve a 3-year term in the Illinois Department of Corrections for the aggravated criminal sexual abuse. That's a 50% sentence. And that carries with it a 2-year period of mandatory supervised release, but again, that will merge with the 3 years to life sentence mandatory supervised release term you're serving in relation to count 1. You understand that? At this point in time, then, you will be remanded back to the Department of Corrections to serve the balance of your sentence, minus obviously the credit you've gotten and received since your July 1st, 2010 date.